The document is called a Statement of Deficiencies. It is Form CMS-2567. The federal government issues one to any certified clinical laboratory found to be operating outside the requirements of the Clinical Laboratory Improvement Amendments, the regulatory framework that governs every lab in the United States that tests human specimens for diagnosis or treatment. On January 25, 2016, CMS transmitted that document to Theranos. It recorded the findings from a CLIA survey of the company's Newark, California facility, a process that had begun 4 months earlier, in September 2015, and that had concluded only after Theranos submitted documentation to CMS in late December. The first deficiency is tagged 42 CFR 493.1441. 1 requirement. The laboratory director bears responsibility for the overall operation of the laboratory. At Theranos, that requirement was not being met. This episode walks through what else the survey found and what the filings should have shown years before it began. The patients came through Walgreens wellness centers. They provided a few drops of blood from a finger prick. The results came back as clinical test reports, the same category of document a hospital laboratory produces, with the same diagnostic weight. Criminal proceedings in the Holmes case documented what some of those patients experienced. Patients received results that led to medical decisions, additional testing ordered, treatment changes made, based on Theranos reports. Months later, those same patients received letters from Theranos informing them that their results were being voided or corrected, that the tests they had received may not have been valid. For that to be possible, for a company to run clinical tests on patients, issue diagnostic results, and bill federal insurance programs, it needed one document, a CLIA certificate. Under Title 42, Part 493, CLIA certification carries legal obligations. A certified high-complexity laboratory must employ a qualified laboratory director, maintain documented quality control systems, and enroll in an external proficiency testing program, running those tests using the same methods used for patient specimens. High complexity is the most demanding classification under the framework. It attests to CMS that the laboratory's methods have been validated, that equipment, personnel, and procedures can produce results that meet established performance specifications. Theranos held a CLIA high complexity certificate. The CMS survey would examine whether the certificate matched what was actually happening inside the lab. Between 2013 and 2015, Theranos raised hundreds of millions of dollars. In investor presentations and materials reviewed during the Holmes criminal proceedings, Elizabeth Holmes, as CEO, described the company's proprietary analyzer, the Edison device, as capable of running a wide range of tests from a few drops of finger prick blood at accuracy levels comparable to conventional laboratory methods. Those representations are documented in the SEC complaint filed against Holmes and Balwani in March 2018. The SEC alleged that Holmes personally made material misrepresentations to investors about the reliability and capabilities of Theranos technology. The CMS survey would later examine the laboratory itself and document what it found operating on the floor. What inspectors observed was not what the investor materials described. According to the SEC complaint, the proprietary analyzer was used for only about 12 of the more than 200 tests on Theranos's published patient testing menu. The remainder were processed on third-party commercial analyzers, some modified to handle fingerstick samples, equipment that did not appear in investor presentations and that was not the basis of Holmes's fundraising narrative. The nature of what that meant for the laboratory's compliance record is what follows. Under 42 CFR 493.801, every CLIA-certified laboratory must enroll in an approved external proficiency testing program. An independent organization sends unannounced samples. The lab tests them. The results are submitted against known reference values. The regulation specifies one critical condition. Proficiency testing samples must be examined using the same methods used for patient testing, same equipment, same personnel. Those remaining tests, all but about 12 of the menu, were processed on Siemens commercial analyzers, including the Siemens Advia, handling fingerstick samples collected in Theranos's proprietary Naina-Tainer collection tube. When external proficiency testing samples arrived, Theranos was routing them to those same commercial analyzers. This created a specific and consequential problem. The performance data transmitted to CMS's approved proficiency testing program, the data that documented to the federal government the accuracy of Theranos's testing, reflected the performance of standard commercial laboratory equipment rather than the proprietary methodology Theranos had presented to investors and patients. Patients at Walgreens locations were receiving results produced by a methodology that the proficiency testing record was not actually testing. The CLIA certificate, as it sat in the laboratory's compliance file, was supported by performance data that did not represent how the laboratory was operating on the days patients came in and had their blood drawn. Under 42 CFR 493.1441, the laboratory director bears personal legal responsibility for the overall operation of the laboratory. That obligation cannot be delegated. It attaches to the named individual on the CLIA certificate, the person answerable to CMS for everything the lab produces. The regulation exists because clinical laboratory results carry diagnostic consequences. A missed quality control failure is not an abstract compliance violation. It is a patient receiving a result the laboratory cannot verify is accurate. From 2012 through November 2014, the laboratory director named on the Theranos CLIA certificate was Dr. Adam Rosendorf, a board-certified pathologist. He resigned. At the criminal trial of Elizabeth Holmes, Rosendorf testified under oath about why. He had raised quality control concerns. He had identified test results he believed were inaccurate. Court records state he resigned, citing concerns about being forced to vouch for results he did not trust. The CMS survey, conducted nearly a year after Rosendorf's departure, found that the laboratory director requirement at 42 CFR 493.1441 was not being met. The deficiency filing records what inspectors observed in the fall of 2015. Rosendorf's testimony documents what was happening in the months and years before they arrived. CMS inspectors were not the first federal officials to identify problems at the Newark facility. Before the CLIA survey began, investigators from a different agency had conducted their own inspection. Their authority was different. Their subject of inquiry was the same blood collection system Theranos was using on patients every day. The Food and Drug Administration regulates medical devices under the Federal Food, Drug and Cosmetic Act. Marketing or using a medical device for clinical purposes requires pre-market clearance or approval. The FDA had not cleared the nanotainer, the proprietary collection tube through which all Theranos fingerstick samples were gathered. Following an August 2015 inspection, the FDA issued a Form 483 noting the unauthorized commercial use of the collection device. The FDA subsequently classified the nanotainer as an uncleared medical device, prohibiting its continued use. The nanotainer was not a peripheral component of the Theranos system. It was the mechanism by which every fingerstick sample was collected. Every patient test run at a Walgreens location had passed through a device the FDA had determined was not legally authorized for that use. 2 federal agencies, 2 inspection documents, 2 separate compliance findings, the same facility, the same methodology. How did this get inside Walgreens? That question has a documented answer. Theranos provided Walgreens with performance data and validation summaries during the due diligence process. The materials described the Edison device's capabilities. They had been prepared internally by Theranos. Walgreens executives reviewed them. Walgreens did not commission an independent technical assessment before the partnership launched. No third-party laboratory evaluated Theranos's methodology. No requirement for independent validation was written into the contract. The investor materials Holmes had presented to funders, the same representations the SEC would later allege were fraudulent, described a device running a full range of tests. The CMS survey would document that the device was used for only about 12 of the more than 200 tests on Theranos's menu. The rest were processed on commercial analyzers. Theranos operated inside Walgreens locations for 3 years. The partnership agreement and the due diligence process that preceded it belong to the documentary record. They are the conditions under which patient testing was authorized and the process by which those conditions went unexamined. The CMS CLIA survey of the Theranos Newark facility began in September 2015. Inspectors spent 3 days on site that month. They returned in November, 4 more days, completing the on-site portion on November 20th. The survey concluded after Theranos submitted documentation to CMS in late December. On January 25, 2016, CMS issued the Statement of Deficiencies. The Form CMS-2567 cited 5 condition-level deficiencies and additional standard-level deficiencies. The condition-level findings spanned quality control, proficiency testing, laboratory director responsibilities, and personnel qualifications. A condition-level deficiency under CLIA is not a technical violation. It is a finding that a foundational requirement of the laboratory certification has not been met. At the conclusion of the survey process, CMS made a single overarching determination. The laboratory's practices constituted immediate jeopardy to patient health and safety. Under 42 CFR 493.2, immediate jeopardy is defined as a situation in which the laboratory's non-compliance has already caused, is causing, or is likely to cause at any time serious injury, harm, or death to individuals served by the laboratory. Immediate jeopardy is the highest severity level under CLIA. It is not a preliminary finding. It is a formal regulatory determination. The surveyors had arrived to conduct a compliance review of a certified laboratory. Their findings concluded that the laboratory posed an immediate threat to the patients it was serving. When CMS makes an immediate jeopardy finding, 42 CFR Part 488 requires sanctions sufficient to remedy the jeopardy. For Theranos, CMS imposed 3. First, revocation of the CLIA certificate. The legal authorization permitting the Newark laboratory to perform high-complexity patient testing would be cancelled. Second, a civil monetary penalty. Third, Elizabeth Holmes, as the laboratory's owner, would be prohibited from owning, operating, or directing a clinical laboratory for a period of 2 years. The prohibition on Holmes is a clear sanction. It requires no jury. It derives from the Form CMS-2567, from the condition-level deficiency findings from the immediate jeopardy determination. CMS imposed these sanctions in July 2016. Theranos subsequently resolved the CMS proceedings through settlement, and the certificate revocation was later withdrawn as part of that resolution. But the sanctions had been imposed. The immediate jeopardy determination was in the record. The regulatory proceedings had largely run their course before any criminal indictment was returned. The criminal proceedings followed separately: the SEC complaint in March 2018, the federal indictments in June 2018, under different legal authority, to the same individuals for overlapping conduct. The regulatory consequences arrived first. Following the CMS findings, Theranos voided all patient test results generated by the Edison device for the affected period. A CMS interview record documented that more than 50,000 patient test results were implicated. Court records described the voiding as non-voluntary. Patients who had relied on those results received letters informing them the results were no longer valid. In some cases, documented in trial proceedings, decisions about medication, diagnosis, and further testing had been made on the basis of results Theranos was now invalidating. The voiding was a regulatory consequence of the Form CMS-2567 and the findings it recorded. It was not disclosed as a precaution. It was imposed by the weight of what inspectors had found. The certification was the signal that the methods had been validated. The inspection found conditions that caused CMS to revoke it. The SEC complaint against Elizabeth Holmes and Ramesh Balwani, filed March 2018, alleged they raised more than $700 million through a scheme involving material misrepresentations about Theranos' technology, its regulatory standing, and the validation of its proprietary device. Holmes was convicted in January 2022 on 4 investor fraud counts. Balwani was convicted in July 2022 on 12 counts, including counts specific to patient harm. The criminal proceedings began in 2018. The CMS sanctions were imposed in 2016. The CMS survey concluded in late 2015. The FDA Form 483 was August 2015. The documents that established what was actually happening inside the Theranos laboratory were regulatory filings: Form CMS-2567, FDA Form 483, CLIA proficiency testing records showing performance data from commercial analyzers for a laboratory presenting itself, in materials signed by its CEO, as running a proprietary device. The certificate existed. The laboratory was authorized. The authorization was based on documentation that did not reflect the laboratory's actual methods. The filings were public. The 42 CFR citations are in the Code of Federal Regulations. The Form CMS-2567 is a federal document. The consequences of not reading them were borne by the patients who received the letters. What Form CMS-2567 shows, read alongside the FDA Form 483, the SEC complaint, and the trial record, is not a story about a founder who deceived investors. It is a story about a CLIA-certified laboratory that submitted proficiency testing data from equipment it was not using for all but about 12 of the more than 200 tests on its published menu, that operated without a qualified laboratory director, that ran a collection device the FDA had not authorized, and that a major retail pharmacy chain agreed to partner with based on materials no one independently verified. The public version of the Theranos story is about Elizabeth Holmes. The regulatory version is about a certificate, a Form 2567, and a proficiency testing requirement under 42 CFR 493.801 that was not being met while tens of thousands of patients received results through Walgreens wellness centers and trusted them. One version ends with a conviction. The other ends with a stack of letters. Next, on hidden liabilities. In December 2022, Silicon Valley Bank filed its annual report. On page 124, in the notes to the consolidated financial statements, the bank disclosed the duration profile of its held-to-maturity securities portfolio. The number on that page, the weighted average yield measured against the rate environment the Federal Reserve had been signaling for months, described a bank that could not survive a deposit run. The 10K was public. The math was not hidden. We will walk through exactly what the filing said and what it meant. Subscribe and you'll be there when it drops.